We meet the Secretary General, sir, Mr. Good evening, everyone, guests on the dais and off the dais, and we welcome you all to this distinguished lecture on a subject that sits at the very nexus of international law, diplomacy, and global economic policy. We are gathered here to delve into the intricate world of investor-state arbitration through the lens of North American experience under the North American Free Trade Agreement compared against the evolving landscape in India. Additionally, we will explore the critical aspect of enforcing investment arbitral awards, a cornerstone in the edifice of international investment law. It is my profound honor to introduce our esteemed speakers for today, Mr. Laird and Mr. Michael Guiffre from the prestigious law firm Crowell and Moring LLP based in Washington, D.C. Their expertise and contributions to the field of international arbitration and investment law are both vast and deeply respected. Just to give you a brief introduction of our speakers, so when geopolitics leads to disputes, Ian clients trust him for his extensive experience in international arbitration and under different treaty rules. He represents clients who are dealing with sensitive commercial and international disputes around the globe. With a key eye for political risk, clients rely on him for his ability to respond quickly and efficiently when the need arises. He is the co-chair of firm's International Dispute Resolution Group. He frequently advises Fortune 500 corporations on geopolitical concerns when their investment face challenges overseas. He has worked extensively with the clients involving issues in energy, natural resource sectors such as power generation, oil, gas, and mining. He represents a range of clients and acts as an arbitrator in international arbitration proceedings, primarily involving disputes between corporations and foreign sovereign governments. For 25 years, Ian has counseled parties in investment arbitrations under the provisions of North American Free Trade Agreement, Canada, United States, Mexico Agreement, and other important agreements. So, with these words, I welcome Ian. And now, Mr. Michael, he is a skilled trial lawyer and litigator with more than 25 years of global disputes experience. He has served as a lead counsel in international and domestic arbitration and federal and state court litigation throughout the United States. He is a partner in the International Dispute Resolution Group. He represents clients in a wide variety of disputes involving commercial and government contracts, construction claims, geopolitical and aviation issues, investor-state treaties, intellectual property rights, business torts, and fraud. He is also adept in litigating contract disputes, bid protests, and other claims against the US government and has defended companies against procurement fraud allegations and terminations for default. He has also managed a wide variety of government and internal corporate investigations and has served for 6 years as an officer and lawyer in the US Army, where he gained substantial trial and appellate experience. He has managed complex contract litigation and fraud investigations. So today's lecture aims not only to enlighten us on technical aspects of investor-state arbitration and award enforcement, but also to foster a deeper understanding of the parallels and divergence between the North American and the Indian experiences. This comparison will be invaluable as it will shed light on broader trends and challenges in international investment law, offering lessons and insights that actually transcends borders. To begin with, I would like to request our President, Shri Praveen H. Parekh sir, to felicitate our guests. And I would also request our Secretary General Sir, Shri Narendra Singh Sir, and our Vice President Sir, G.V. Rao Sir, to present the publications of the Society to our esteemed guests. Thank you so much. Now it is my honor to call our President, Shri Praveen S. Parekh Sir, to deliver the presidential address.
Good evening. Our two very distinguished guests who have come to ISI, Mr. Laird and Michael, my friend Mr. Narendra Singh, and Mr. G.V. Rao, Vice President of the ISI, ladies and gentlemen. On behalf of the Indian Society of International Law, it is our honor and privilege to welcome our esteemed guests, participants and friends to this distinguished gathering. ISI was established in 1959. ISI has been a beacon for the study, research and promotion of international law in India. We are very happy that we have both lawyers, the teachers and students, and that makes us complete because there are a lot of things which we learn from teachers, and these days we learn a lot from the students. We know much more than what old man like me knows. It's very good to learn from them, and it's very nice. Today we are privileged. The two eminent guests have come to us and will be from the USA. They'll be presenting a seminar on critical topics in the field of investor-state dispute settlement. Their expertise and insights will undoubtedly enrich our understanding of these complex issues. In fact, there is investor-state dispute. Of course, when there are dispute, one does not like disputes, but the disputes do take place at times, and they take place, then it is necessary to see that the disputes are settled quickly and very, very properly, so that it is nobody thinks that what has happened is not just or fair, etc. The first topic, the development of investor-state arbitration, the North American experience under North American Free Trade Agreement. We like to understand what is happening there, because we also have a lot of arbitration, etc. But it is something we will like to learn from you and understand from what you would like to say. The investor-state dispute settlements, because when there are disputes, then there has to be settlement, and that is very important. How do you settle? How you should settle it fairly and properly and quickly. The recent reforms in investor-state dispute settlement is called ISDS at the institution like the International Center for Settlement of Investment Disputes, ICSID, and the United Nations Commission of International Trade Law, Working Group 3, have sparked significant attention from government worldwide. These reforms have focused on revising dispute procedures and substantive applications in international investment agreements. One of the most notable events in recent years was the termination of the North American Free Trade Agreement in July 2020, replaced by the United States-Mexico-Canada Agreement. This transition witnessed a notable shift in investor protection in North America. In fact, I have written a 4-page speech. I need not speak full of it, but I will be able to give copies and you can have a look at it. Thank you very much.
Thank you so much, sir. Now please join me in extending a warm welcome to Mr. Laird and Mr. Michael Guiffre, and seize this opportunity to broaden our horizons and deepen our understanding of the complex and dynamic field of investor-state arbitration. We welcome you, sir.
Well, thank you. Thank you so much for that warm welcome. I really feel that we're here amongst friends at the ISIL. Thank you for your warm remarks and providing an introductory to some of the comments and the issues that we'll be discussing. When I was thinking of how to proceed with this presentation, I thought it would be useful for this audience to have the perspective of a practitioner who's been working in the investor-state arbitration world for over 25 years, but in the context of a different market and a different part of the world from India. But also look at it in the sense that there are many similarities and areas of comparison that arose when I was looking specifically into the Indian experience. Now, I don't want to presume to tell you about your own cases and about your own treaty practice, but it's interesting to look at the comparisons because, as I was saying, I think there's a lot of similarities in the experience with investor-state dispute settlement. So when I started as a young lawyer, and I see we have a number of students and young practitioners here, ISDS, investor-state dispute settlement, was relatively new. And we're talking about, over 25 years ago in the late 1990s. And at that time, ICSID, the International Center for the Settlement of Investment Disputes, was only 35 years old at that point, having been signed in 1966. But there had only been a handful of cases up to that point in time, maybe 30 to 50 in that range, depending on how you counted various annulment cases. So there wasn't a great deal of experience, and that was also in the early days when many countries like India and like Mexico, Canada, and the US were first signing the new generation of bilateral investment treaties. And you saw in the 1990s and the early 2000s a lot of enthusiasm for those treaties. And the NAFTA, which was signed and came into effect in 1994, was an example of a lot of innovations and new types of provisions and procedures in that type of treaty. The Energy Charter Treaty was also an example at that time of what I would call the kind of American model for these treaties, which stood in contrast to the type of model we were seeing from European countries like Germany and the Netherlands, which tended to be much shorter and more perfunctory and more reliance on general international standards. So when I, as the young lawyer, like some of you, came into this, we didn't have a lot of case law. We just had the benefit of the development of public international law more generally, and I think that probably resonates with a lot of the folks here at the ISIL who've also grown up in a world which, we just didn't have the benefit of that kind of jurisprudence. But the one experience that I gained as a young lawyer practicing in the North American context and under NAFTA was that we started to develop much of the case law and some of the procedures that helped advance the field, but also started to create some tension, to say the least, as we had more cases in the NAFTA context. You saw more critiques because there's nothing academics in particular like than a juicy decision or award to chew on and to analyze and to provide context. And so this was a boon for academics, but it was also something that was a boon for experienced counsel as well as negotiators. And in the NAFTA context, unlike India, all three of the parties, Mexico, Canada, and the US, have bureaus which specialize in NAFTA cases. And so they developed an internal expertise of counsel who would be the repeat counsel as government officials on those cases. In the case of Canada, they call it the Trade Law Bureau. And these are individuals who represented Canada in WTO cases, as well as whatever international case there may be. You had the Legal Advisor's Office in the United States, which was resident in the State Department, and then Mexico, similarly, in the Economic Ministry, had a legal office. And so what you had is a development of a fairly in-depth expertise by these officials, who also then became treaty negotiators. And so they were able to take that experience and to apply that in developing innovations and revisions and adjustments to their international regimes and through model bits and just through treaty negotiations. So it really much a reflective of the nature of international law and treaty law as in development, and that we have these periods of lower activity and higher activity, and we have cases which help inform the development of the law. So we have this context of which both, I think, India and the NAFTA parties were pretty, what I would call eager and early adopters of investor-state arbitration. And for the first 10 years or so, relatively 10, 15 years of those regimes through the 1990s and into the 2000s, there weren't a lot of cases, so it didn't attract a lot of interest. And just to give some statistics, because I know audiences love statistics, when you look at the bilateral investment treaty regime, and I'm citing from the UNCTAD, the UN Commission on International Trade and Development, they've kept these statistics. Mexico has had and continues to have 31 bilateral investment treaties, the US 45, Canada 39, and most of those were signed in the 1990s and early 2000s. And in contrast, of course, we have India, which signed over 87 bits, mainly in the in the 1990s and 2000s. And of course, we know roughly 77 of those have since been terminated. And I'll get to that part of the discussion because I think there is some convergence and parallels between the NAFTA zone and India on that front. So just to step back a bit, I was thinking of how I should put this kind of comparison exercise and the context, what a good analogy would be. And I had thought that we could compare the investor-state regime to kind of like a restaurant, and that you have items on the menu in the restaurant which then are produced like the cases. So you have the treaties or the menu, and then the meals are the actual cases. Or the other analogy could be of a relationship. These types of treaties and agreements are a form of contract. agreement. Underlying them are concepts of trust and good faith, as is typical in treaty regimes. And so you could almost analogize it to a form of marriage. There's a lot of trust involved, like in all marriages, that requires mutual reciprocity. And so, there's some ways of looking at this. So we have a very enthusiastic restaurant menu or marriage, as you want to apply that analogy. But as we move into the actual practice, we've seen that has been viewed, and this is, I think, in the case of India and as well as in the NAFTA zone, that some of the early cases were very contentious, and they drew the attention of not only government officials, but of the wider civic society, the economic community, which perhaps was less supportive of international trade. And investor-state arbitration, and certainly some of the early cases I worked on, did attract some negative attention. And some of those critiques were that the procedure was too secret, for instance, or that the standards were too onerous, etc. And I think when I look at the parallel of some of those early cases, an early case that I didn't work on was called the Lowen case, and some of your students may study this case. Lowen was a case against the United States by a Canadian investor. Mr. Lowen owned a franchise network of funeral parlors, of which he'd been very successful in Canada, and he went to the United States to create and purchase and get involved in the funeral business in the southern U.S. states. And in this case, the state was Mississippi. And he got into a fairly contentious contractual dispute with one of his franchisees. And the claim was about $6 million, not a substantial claim. But he faced a lot of pushback from the court. The judge was openly biased against the Canadians, instructed the jury basically to be biased against them, would admonish them publicly in court. It was really not very judicially, a very good judicial performance. And I think by any standard would have been viewed as subpar. But Mr. Lowen lost, his company lost, and being the United States, the jury has a great deal of ability to render decisions. So it wasn't a $6 million award, it was a $500 million punitive damages award against Mr. Lowen for a $6 million value claim. And for Mr. Lowen to appeal the case, Mississippi has an interesting requirement for an 125% bond. So he would have had to put up a significant amount of money to simply carry on his battle. And so we hear repeatedly that the United States has not ever lost a case. And that's kind of one of the kind of statements that the United States likes to say. We haven't lost an ISDS case. But in that case, Mr. Lowen did succeed on the merits. The tribunal held that there was a denial of justice. The result was overturned in a subsequent judicial or jurisdictional decision by the tribunal that since Mr. Lowen went bankrupt and sold his company to an American company, that he lost continuous nationality, which in the community at the time was believed to be a fairly dubious conclusion that continuous nationality was required, particularly the fact that Mr. Lowen was also suing in his own personal capacity. He never lost his Canadian nationality, but regardless, the United States succeeded in that case. And this is the early 2000s period. And one of the other markers of that period was also the NAFTA parties did a joint interpretation, which, as you know, under the Vienna Convention is quite permitted. The parties to a treaty wish to do an interpretation of particularly parts of the treaty that are contentious, that they can get together produce that type of interpretation, and the NAFTA itself is a very specific provision. It sets out a free trade commission mechanism that allows for these types of interpretation. And there was an interpretation taken in 2001 that addressed some of the issues that were live in these types of cases, like Lowen, in particular being the definition and the content of fair and equitable treatment was the main topic of this Free Trade Commission interpretation, but as well a statement concerning transparency. And we see the early roots, of course, of the development of the transparency regime that would later become the Mauritius Convention at the instigation of the NAFTA parties in that early Free Trade Commission interpretation. But so we see a lot of activity in the early 2000s with NAFTA parties trying to adjust and deal with cases like Lowen and others that were dealing with many of these ideas. And we saw similarly a few years later in the context of India, cases like the white industry case, which I don't need to tell you about because it's a very famous case in that, again, we were dealing with the court system, which is very contentious when international tribunals take on courts in some manner. And again, it was a case in which the courts came under a form of challenge by these international tribunals, and it was something that frankly was novel enough and new enough for particularly the general public and critics that it created a certain amount of tension, as I understand it continues to do so. So it's not unusual, I think, amongst public international lawyers when you study the laws of state responsibility and what entities in a government are considered, part of a government per se. It's not surprising for us that courts may be subject to international standards, but I think for politicians in particular and individuals who haven't taken classes at the ISIL or in your law schools may be a little surprised at that. And certainly in the case of the Lowen case, notes came from the White House at the time, basically asking, how can this possibly be? How can a United States court in the great state of Mississippi be subject to international sanction? And of course, like many of you who have worked in the external affairs or State Department type atmosphere, a memo came back to the White House basically saying, oh, dear Mr. President and your advisors, you should talk to the Secretary of State. In fact, this is quite possible, and in fact anticipated under these types of treaties. But that didn't make it any more palatable. And in the final subnote on the Lowen case, which has been a particularly interesting case, is that the American appointee in that case, Judge Abner Mikva, later gave a speech, much like we are here today, years later, talking about the case. And he basically admitted that he believed that case for him as the U.S. appointee was existential for the NAFTA and for international dispute resolution. And he was very aggressive in getting the result and working with the other arbitrators to make sure that the U.S. didn't lose that case. And I guess from an Indian perspective, you said, oh, I wish our arbitrator in white industries had been a little more assertive. But it really shows you that these cases can have a great depth and importance in terms of how they impact the political culture as well as the legal community. And I wanted to kind of go back to some statistics as well, because I don't think we're actually that much different in North America in terms of how these cases have been handled. I did some of the math again, the statistics from UNCTAD, and in the NAFTA context, there's been 108 cases over basically the last 25 years with each of the parties. In Canada's case, 34 cases, the US 24, Mexico 50, and the rate of success of investors has been roughly in the NAFTA zone about 20%. Success for investors, and that includes quite a bit of settlement and cases withdrawn, and so forth. And when you look at the India stats from UNCTAD as well, the success rate for investors is only about 23%. The problem is that all those cases were tended to be bunched up in that certain period around 2015 and earlier, maybe a little later, and definitely created that atmosphere, I think, that generated the model bit in 2015. And you can see the motivation, the experience from those cases. But when you compare the 21% in NAFTA and the 23% in India, and you compare that against the UNCTAD overall statistics, over 1,300 cases that have occurred basically in the last 20 years, the win rate for investors is 28%. So if you compare the overall statistics, actually Canada and the US and Mexico and India are relatively in the same range. I think the US is a bit of an outlier. They've really never lost a case. But in terms of Mexico and Canada, they've probably lost more cases than India. So it's when you look at these things from a broader standpoint, there's more similarities than you would think. But that being said, part of the reaction, and I think we heard it from Mr. Park, in Canada and the NAFTA zone in particular, has been the end of NAFTA Chapter 11, which is the chapter on investor-state arbitration. So I worked on some of the earliest NAFTA cases, and now I'll be working on one of the last ones. There's a legacy provision in the new US MCA, the US-Mexico-Canada agreement, which has allowed for a 3-year, basically, sunset period. And I'm involved in one of those cases on behalf of the government of Alberta, which is a party to one of the, there's a number of cases concerning the Keystone XL pipeline, which was canceled by President Biden the first day of his administration. And so that's going to be one of the last NAFTA cases as between Canada and the United States. And we've seen questions around that, about whether this is an indicator of the NAFTA parties retrenching on ISDS. And I would think safely confirm now after 2 years or more from the termination that though the parties really have not changed their overall program or their treaties, it hasn't led to further termination. Outside the NAFTA zone, ISDS is still very active. And I think part of the proof in the pudding of that is that the outgoing investment perspective, Canada investors abroad using bilateral investment treaties have over 67 cases. The United States has 226 cases over the last 20 some odd years. And that really kind of points to the reciprocal nature of these treaties, that even if the party has had some losses, that they do, it's important to have that reciprocal element, which is very, consistent principle in international law. So I wanted to just finish to follow up on just a little bit of substance, because I think this is another area of parallel, and to talk about the fair and equitable treatment standard, which is perhaps the most used standard in bilateral investment treaties, and one that has been subject to the most critique. In the model bit produced by Canada, and in particular, I think there's some alignment with the model bit in India, which I think has taken some criticism that the Indian model bit doesn't address a number of elements of what you could call the customary standard of fair and equitable treatment concerning arbitrariness and legitimate expectations. But that's actually not unlike the Canadian model, which also is very cautious about the legitimate expectations element of fair and equitable treatment. And that is the one part that has in particular attracted attention of critics of that particular standard. And so we don't see a lot of deviation back there because there's still an acknowledgement that under customary international law, in particular, denial of justice still applies, prohibition against against discrimination, non-discrimination standard, and acceptance that due process is required is basically well accepted, whether it's under the India model or the Canadian model or the US model treaty itself. So there's a lot of convergence in terms of how they view those substantive standards. But I don't think I have time to get into the other areas of similarity and divergence, but how full protection and security is handled is very similar, focused on the physical standard. MFN seems to be an area of contention, although I think there's a general agreement that applying MFN on a treaty basis is something that the parties shy away from. How pre-investment is handled, of course, is always a big difference between any other model in the North American type treaties, which the Americans and Canadians are very keen on having national treatment applied to pre-investment, but most other treaties, including the India model, that shy away from that fairly contentious area. And of course, transparency is one of the areas which we've seen a lot of aggressive activity by the NAFTA parties in support of transparency. But despite the fact that we've had the Mauritius Convention, there seems to be still a general difficulty in the take-up by the international community for full transparency of international arbitration. And I know India continues to work on that area as well. And we all hope to see more transparency provisions. So just to finish then, I guess using my analogies, if we look at kind of the marriage analogy, we've seen some rocky parts of the relationship in terms of how the NAFTA parties have viewed ISDS, but I think they've been going to a marriage counselor and they're trying to make it work. In the India context, we've seen a bit of a divorce, quite frankly, but an attempt, I think, some attempts to get back together and engage with the treaty regime, hopefully following the many innovations in that treaty. So the relationship, like all relationships, is one that continues, and I think we'll see continued developments and innovations and activity in this field in the future. And I hope I have an opportunity to come back in 25 years and have a further update discussion on what has happened. But thank you very much for your invitation.
Sorry. All right, well, I think you can see why we call him Professor Laird. And I will have a bit of a different approach to what I will talk about, which is post-award enforcement. And look at it from the perspective of the less cerebral, theoretical, and interesting type of discussion, and perhaps more of a nuts and bolts consideration of this particular issue, followed by a case study. If you just envision yourself that you have won the biggest award of your career. It's the pinnacle of your career. You just got $1 billion award against a sovereign state. And I'll use the French Republic just for an example here. As we talk through, it may make it easier to follow. Well, what do you do when France says, okay, so what? I'm not going to pay you. And for that, arbitral tribunals can't really help you. They don't have an enforcement mechanism to actually make the sovereign state pay. And so at the end of the day, you end up with a piece of paper. And you and probably also have another active coin as well. So an arbitration scheme that is intended to enable parties to avoid litigating in court actually forces you to go to court at the end of the day if you have a recalcitrant sovereign that is not paying the award. And so we'll talk a little bit about how you go through judicial proceedings, but there's a two-step process in general. You have to have a national court of a state recognize and enforce an arbitration award, at which point it's generally converted to a judgment. And then you have to execute that judgment according to the domestic procedures of the state in which you are in to collect assets to pay that award. And so generally, you need to go through this process. Where am I going to do this? Where am I going to sue? And there is an option as the awardee to pursue enforcement of your award in the seat in which the arbitration was conducted. But if that seat is Paris, there may be some reluctance to go to the French national courts to enforce a $1 billion award against that country. And you may, at that same time, be facing efforts by France to annul the award, depending on the regime we'll talk about. So quite often you'll see that parties look to other states for means to enforce an award. And for that, there are basically two general mechanisms or conventions that parties look to. And one of them is the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is called the New York Convention, much easier to say. And then the other is the ICSID award, the ICSID Convention, I should say, which is an investor state specific convention that enables you to pursue collection efforts. And depending on which convention you utilize, you have a different process. And for that reason, it's important to look at what type of award you have, whether you went through ICSID or a separate arbitral regime like an ICC process or an ad hoc UNCITRAL arbitration. And then you need to look at the state where you are trying to collect on that award, and is that state also part of the New York Convention or the ICSID Convention. So let's say we're looking at the ICSID Convention. What happens in terms of the very first step? I want to recognize and enforce my award. I want a court to do this. Well, the unique thing about ICSID is that it's final and binding. And when you go to court to execute on that award, all you have to do is submit an authenticated copy of your award, and the court is required to accept it. They can't look beyond it. They are supposed to treat that as a final binding award and enforce it. And so that is something that is extremely useful in terms of your ultimate journey to collect on that award. Now, there is an opportunity for France to contest that award, but it has to do so within the self-contained regime that is part of the ICSID Convention. There are certain grounds that a sovereign state can raise in an effort to undo an award that has been entered against it, and those grounds are specified in the ICSID Convention. And they're limited. They're restricted to whether the tribunal was properly constituted, whether the tribunal manifestly exceeded its powers when it issued the decision that it did, whether there was some corruption in the tribunal on the part of a member of the tribunal, whether there was some serious departure from a fundamental rule of how the arbitration was to be conducted, and whether or not the award failed to state reasons for the decision. And that's pretty much it. There's not a lot of room there for the state to identify or contest, quibble with what the tribunal decided. There's no do-over. The issue is whether or not you had a fair opportunity the first time. And so if France has gone through that process internally within ICSID and lost, when you have that award in your hand and you go to court, the national court of whatever state it is you're seeking to enforce it in, must accept it. We will talk about some unique aspects thereafter of what may happen just when you think that you've secured victory. Second thing is sometimes you will end up pursuing these under the New York Convention. And the New York Convention is different. It doesn't have the privilege of that self-contained mechanism for annulment of an award. And so you can see if the investment treaty award is issued within the context of, let's say, an ICC arbitration, and the New York Convention applies, well, now France can go to its national courts and try to get that award annulled pursuant to its own arbitration laws. And it can also object to the recognition and enforcement in the state in which you're trying to get it recognized. Let's say we went to the United States. We filed our petition to confirm and enforce the award. If it was ICSID, that would be it. The judge would say, here's the judgment. But because we're dealing with the New York Convention, France can come in and say, oh no, there's a whole lot of reasons why you, judge, should not enter a judgment against me. And the convention itself, although the New York Convention does have a very strong mandate that awards are supposed to be final and binding, it includes certain exceptions that can be cited by the state to say that we did not get a fair opportunity in this proceeding and the award should not be enforced. Some of them are similar to the ICSID convention, but there's some variances. One is that there's just no valid arbitration under which this award was issued. Another one is violations of due process. Did the party have the right to, for example, present all of the evidence that it wanted to present? And if not, that could be a ground for refusal to recognize and enforce the award. Again, if the tribunal exceeds its authority, that could be a ground for refusing to enforce. If there's some form of irregularity in informing the tribunal or following the processes. If the award is not yet final, we'll often see that the state will say, for example, if it is pursuing annulment proceedings in the seat nation, it may say, hold on, let's stay the proceedings here in the United States while the annulment process works its way through the French court system. And then finally, if France were successful in getting the award set aside, then at that point, it can argue in the United States there's no longer an award to be enforced. And finally, there is a public policy exception that is incorporated into the New York Convention, and that is not defined. So a court in the United States could refuse to recognize and enforce an arbitration award if it finds that doing so would be against the public policy of the United States. But what does that mean? And countries that have addressed this have come out in different ways on what they think is a proper public policy exception to enforcing an arbitration award. And we've seen in India that India tended to take a very encompassing perspective on what public policy meant and would refuse to recognize and enforce arbitration awards where it felt that there was an error of law, something that other countries would not consider to be a public policy ground. And I believe that under the Indian Arbitration Act of 2015, that's now been reversed and is specifically excluded as a ground for refusing to recognize an award. So we've seen a change in policy here in India about this. And so you've gone through this process, and in both the New York Convention and the ICSID Convention, with the exceptions that are identified, the one thing that is clear is that arbitrations are not supposed to be conducted twice. And so when you get to court, after you have your arbitration award, you can complain about the process. Did you get your fair opportunity to defend yourself? Was the procedures and the tribunal that were constituted for the arbitration, was that done properly? But you don't get to say they made the wrong decision. And that's a fundamental principle. In reality, when you are in court and contesting the execution of an arbitration award, sly attorneys, creative attorneys will figure out ways to try to re-argue the underlying facts, either through making it a procedural due process issue. I didn't get an opportunity to present this evidence, and if I had, I would have won. And try to pull the court down into the facts again. Something that courts often will not do, usually will not do, but you can see some decisions out there that do incorporate some assessment of merits. All right, so we've gone through now, and we've successfully obtained a judgment from the court in the United States that recognizes and enforces the arbitration award. Now what do I have? I have a piece of paper. I don't have any money yet. I still haven't collected my on my award, and my client's still not happy. So now you have to execute the judgment. And here in this circumstance, you are now playing by the national court rules. Now the New York Convention and the ICSID Convention, you can't easily look at them, the text of them, and see, what do I do? How do I collect this money? Instead, you now need to look at the particular rules of the particular nation in which you are litigating. And you will see that one of the most common problems that you run into in trying to enforce and execute on a judgment is sovereign immunity. Sovereign immunity is recognized in pretty much every country, and it can become a serious impediment, if not foreclose altogether the opportunity to collect on an award. You will see that in many countries, sovereign immunity does have certain limits. For example, in the United States, under the Foreign Sovereign Immunity Act, if you have a foreign sovereign or also an agency or instrumentality of the foreign sovereign, which we'll talk about in this case example, then you've got the FSIA applies and you've got immunity, unless an exception applies. And many states will include a specific exception for arbitration. If you agree to arbitrate, then you are not immune from collection on that award. That sounds great, doesn't it? But in reality, just because you can continue to execute doesn't mean that you're good. You then now need to look at, all right, where's the money? And when you find those assets, can you actually get them? Because even if the sovereign immunity does not apply, assets themselves may be off limits. If the assets you identified are bank accounts that fund diplomatic operations, consular operations, then you can't get them. If you are going after the assets of the national bank, you're not going to be able to get that. If you are going after that sovereign state's museum exhibit that is on display, probably it's still going to be covered by immunity. And any military associated items or other things of a governmental nature pretty much are going to be off limits. Instead, what you're going to end up with is looking for assets that can be characterized as commercial assets. And that will lead to disputes between the award holder and the foreign sovereign over whether those assets are commercial assets or not. So more fighting in court. And also more difficulty finding those assets. You end up in a situation where when you first start off with your piece of paper and what's next, you're going to have to look, where are the assets? What are those assets? Are they commercial assets? Are they in a country that is a member of the ICSID Convention or the New York Convention? Am I going to be able to overcome the exceptions to enforceability? And what happens with the individual rules of that particular nation in execution? So let me move on now to the example that I think may be very relevant here. Some of you, probably most of you, have heard of the Davis versus Antrix matter that has been going on for, I think, about a decade now. where Antrix is the commercial entity that is an arm of the Indian government and its space organization. And you, yes, back in 2005, if I remember correctly, Antrix entered into a satellite communications contract with Devis, another Indian entity. And then ultimately Antrix ended up terminating that agreement. Devis pursued an ICC arbitration against Antrix and won an award in 2015, I believe it was. Now, this particular arbitration was a commercial arbitration. It wasn't an investor-state arbitration, although there have been several related to this particular matter with Devis. But for purposes of this discussion, the principles are going to apply in the same manner. Devis now has an arbitration award, and what does it do? It goes to the United States and to try to collect on it. It files its petition to confirm and enforce the arbitration award in Washington State. And the judge grants the petition and enters a judgment against Antrix, which today is valued at about $1.6 billion. Antrix appealed that decision up to the Ninth Circuit Court of Appeals, which is the appellate level right below the U.S. Supreme Court. We came in and represented Antrix at that point. And we made 3 arguments on appeal on why this decision should be overturned, reversed, and the arbitration award not enforced. And the first one is similar to what we just covered. With the New York Convention, we argued that there was no arbitration agreement to arbitrate before the ICC, where the arbitration happened. We argued that the arbitration agreement provided for an ad hoc arbitration. And the ICC accepted the arbitration filed by Devis over Antrix's objections. The arbitral tribunal was appointed in accordance with ICC rules instead of the rules that were specified in the contract. It was a classic New York Convention argument that you would expect to see in one of these types of proceedings. We also argued that there was no personal jurisdiction over Antrix, that the court could not take the case. And we argued the doctrine of forum nonconvenience to say that the case did not belong in the United States. The Ninth Circuit looked at all of this, and it granted Antrix's appeal. It reversed the judgment and threw it out. And today, there is no judgment in the United States that Devis could enforce. But what the court did is it decided that there was no personal jurisdiction over Antrix, and did not reach the questions about whether the New York Convention exception applied or forum nonconvenience. Instead, it looked at its own procedures and laws within the United States to determine whether the court could exercise jurisdiction. In the United States, a foreign sovereign, as I indicated, is entitled to immunity absent certain exceptions. And that also applies to a commercial enterprise that is owned by a foreign sovereign. So India's wholly owned entity, Antrix, is considered to be a foreign state entitled to immunity. Then the exception for arbitration applies. And at that point, you would think that it's all over. Antrix is going to be responsible for the judgment and have to pay it. But within the United States, there's the question of constitutional due process. Does a foreign state have a right to constitutional due process in the United States? And the Ninth Circuit said yes. And because India, the government of India, would be entitled to due process in the United States, that Antrix would be too. And what does that mean? In order to have due process, there must be sufficient contacts between Antrix and the United States that hauling it into court is something that could be expected and satisfies traditional notices of fair play and justice. So you look at the contacts that Antrix would have there. And generally with a company, you look at it. whether it is at home in the jurisdiction. Is it incorporated there? Antrix was not. Does it have its headquarters there? Antrix does not. Does it have specific conduct in that jurisdiction that relates to the claims before it? No. This was a contract between two Indian companies that would be performed in India, governed by Indian law, and had nothing to do with the United States. So if due process is a requirement and Antrix can invoke that constitutional right, then at that point the court has no jurisdiction whatsoever. And so that's what the court decided here. It decided that the law was misapplied by the district court and reversed it. Where do we stand now? And I think so. The lesson to take away from that is that you may be thinking, I am an international arbitrator. I know how to enforce awards, and I can do all this. But then you're really focusing on the conventions and the specific exceptions that you learn in law school, that you practice in annulment proceedings. But you don't really think about the fact that at the end of the day, when it comes to getting that money, you're also going to have to meet whatever the requirements are of the national court and the jurisdiction in which you're located. And for that reason, we have this unique twist in the Antrix case. It wasn't based on the New York Convention, it wasn't based on the ICSID Convention. Instead, it was based on U.S. constitutional law. Now, where we stand today with this is that that Davis is pursuing a petition for certiorari at the U.S. Supreme Court. And you know that it is very rare that the Supreme Court will accept a case. They don't take many each year. What's interesting here is that we're dealing with issues of foreign sovereign immunity, which the Supreme Court likes. We're also dealing with a situation where we have a split among the appellate courts. Some courts think foreign states have due process rights, and other courts say they don't. And as a result, with this split, the Supreme Court may be more likely to look at it. If this goes to the Supreme Court, the issue will not be whether Davis has the right to the relief that's sought in the arbitration. It won't really look at whether the procedures of appointing the tribunal were fair. Instead, the Davis case will focus on whether the Indian government and every other sovereign state has due process rights that protect it from the U.S. courts exercising jurisdiction and deciding claims against them. And so if that were to happen, we would see the Davis case cited in many different situations, not just within the arbitration enforcement arena, but everything dealing with foreign sovereigns. This case would be cited and become a very, very important case. So more publicity for Davis and Antrix. I think that's all I have. Subject to any questions.
Thank you so much, sir. Now we can take a couple of questions.
Yeah, you can. Please.
Good evening. I had a question regarding enforcement of non-exit awards, particularly in states that have taken a commercial reservation. There is some ambiguity on whether investment awards can be enforced in states that have taken commercial reservations. So could you tell us your experience regarding this issue?
Well, obviously, as your question suggests, it depends on the state. For instance, my experience in Canada, there's legislation which is very explicit that treaty awards and so forth are considered under the commercial definition, so that there is no ambiguity about that they can be enforced and not enforceable. Obviously, that becomes a problem in other places where they don't have kind of legislation or regulations that provide that clarity, but it really is dependent. And yeah, no, it can be a problem, obviously.
Good evening, Ian. My name is Arpit, and I had 2 to 3 very short specific questions. My first question is, you mentioned about the NAFTA cases, and it's quite incredible that USA has not lost a single NAFTA case despite being a respondent in 24 NAFTA cases. So is there a particular reason or a strategy that USA followed, and how did it come across? That's my first question. My second question is regarding the enforcement of ICSID awards, and particularly regarding resisting the enforcement of ICSID awards by the Kingdom of Spain, especially in the post-ACME scenario, because that's not one of the grounds on which you can actually resist the enforcement of ICSID. I mean, there's an automatic enforcement mechanism. So that is my second question. And the third question is something which I have been wondering about, is whether signing up the New York Convention imply a waiver of sovereign immunity for the state for that particular arbitration where the New York Convention is being tested. Thank you.
I would just say for the third one, that in general, the agreement to join the ICSID Convention is not viewed as a waiver of sovereign immunity itself. For purposes of the U.S. Foreign Sovereign Immunity Act, that does not come in that exception for that particular U.S.
So to your other questions, first one, why has the United States never lost? And as a Canadian, I can say all sorts of things, but because I've got my American colleague here, I'll say it's because of the excellent legal talent that Americans demonstrate. Yeah, no, that is a conundrum. I've been opposite the U.S. in a number of cases, and I think the quality of the advocacy is just very high, and I think that's a nice explanation. I mean, they fight very hard, I think, is another explanation. They put a lot of resources, and there's some amount of, I think, good fortune as well. The loan example is one case. And there have been a few what I would call Pyrrhic victories as well. So it's not exactly, as employers know, there are wins and then there are wins. And sometimes, even if the result appears to be a win, there can be negative elements. I mean, I'll give you one example. A case another NAFTA case called Klamath Gold, which colleagues of mine brought before I came to Crowell and Mooring. The result in that case was basically an acknowledgement that there had been an expropriation, but that the expropriation had no value. So that the property had no value to be compensated. And that was the view that compromises that tribunal in kind of squaring the circle in that case. To your other question with regard to the situation in Spain and Europe in general, as you know, there's been a bunch of case law, part of it in the French courts, which reflected ultimately the policy of the European Commission to end ISDS, at least amongst European states. And I think the courts basically followed that. For those cases involving, in Spain, for those cases involving other European claimants, I think those cases obviously could have potential problems. Many of the claimants, though, in those Spain cases are non-European. So in that case, those awards won't be subject to that objection. Although if they cited their case, ceded their case in Paris, there may be some problems because that court is being known to take views which even go beyond the EU context. So I think we have to wait and see how those cases are enforced and how they've progressed.
Yeah, good evening, sir. I have a little query in essence of the first question. So there are only two systems which are at work for the enforcement of awards. First one is New York Convention 1958 and the Exit Convention. So suppose that one country which specifically adopt reservation under Article 2 Clause 1, which reads as, I quote, in respect of a defined legal relationship, whether contextual or not. So here, in case of India, India specifically adopted a reservation on the term contractual. So now, here is the ambiguity that what happens if a BIT investment awards came here for the enforcement in Indian jurisdiction, then this reservation came into picture. So,
good evening. Thank you for coming in and addressing us here. My question is that given the experience over the years in international commercial arbitration, the larger umbrella, not just confined to the investment disputes, some maybe commercial or investment you may call that, do you see that we are anyway closer moving to a easier regime of enforcements across different states where the award is pronounced either by ICC or by the Permanent Court of Arbitration elsewhere? Because from the Anthrax Devas case which you just cited, which is more relevant for the Indian system today, the Indian courts have rejected all of Devas claims and they have held it to be a fraudulent agreement, and the $500 million or $1 billion that was, that was the award that was given by Permanent Court or the ICC couldn't be enforced. And now you're saying that Devas is knocking at the doors of the Supreme Court. So my question again I have to say is, how close are we to greater enforcement of awards, foreign awards, investment, commercial disputes across the globe? Thank you.
Well, I would say that first of all, with Antrix, you're correct that that award has been set aside, and if we ever did end up with a remand of the case back down after a Supreme Court review and the court were to reconsider whether the award should be enforced, we certainly would be arguing there is no award to enforce. India has set it aside and it no longer exists. And that is something where, I think around the world, courts are generally receptive to that argument, that if an award has been annulled or set aside under the New York Convention, that's an exception to enforcement. And the presumption is that it will not be enforced. But there are always exceptions to the rule, and courts will look at what the underlying facts are in some circumstances to determine whether or not there were procedural irregularities, corruption, and so on. I had a case once where in Honduras, after an award was issued against Honduras, it was set aside by the Honduran Supreme Court. Well, the president of Honduras had called a press conference and had the Chief Justice of the Supreme Court standing next to him and argued this award will never be enforced. And so those factual circumstances gave the U.S. court cause for concern about whether to set aside is something that should actually be enforced. So I think that goes to overall my view that all of these regimes are a matter of contract, really. It's the treaties that the individual states enter into and the exact terminology that is part of them. But you run into, for example, as I pointed out earlier, the public policy exception and no definition to it. And so as a result, you're always going to have decisions where judges are trying hard, but they are trying hard looking at the individual factual circumstances of cases and trying to achieve that equilibrium, that consistency, but not always doing it exactly the right way, because it's almost an impossible task. And different views in different states about how the judicial system should work. I don't think there's an easy solution other than perhaps something like ISIL helping to work on promulgating or really promoting standardization in how the treaties are applied in different countries.
Well, thank you for your very detailed explanation about the disputes. You mentioned the white industries case in India, how the international tribunal found against India because the courts in India had not decided on the dispute which was pending regarding an arbitration award, which was the sale of white industries. Now, India, as you mentioned, had given notice of termination of a large number of its agreements and has come up with a new draft in which it proposes an extended period of recourse to domestic remedies, and only then you can go to the international remedy. Now, when we were negotiating our investment treaties starting in the 1990s, the concern was that if you put in a requirement of exhausting local remedies, of going to the Indian courts and then going to international arbitration, then it would be seen as appealing to an international tribunal against decisions of Indian courts. And that was an impression that government wanted to make. Which is why the investor had a choice. Either he could choose a domestic remedy, in which case he would have to stay with that remedy, or he could go for international arbitration. So that also did not work. And now we are going back to a situation of first having a domestic remedy and then for international arbitration. Now, the Supreme Court, after the White Industries case, there had been some arbitration matters before that where the interpretation which the court placed on the Indian Arbitration and Conciliation Act, it actually led to almost removing the distinction between domestic and international arbitration. And it was only after White Industries that the court took a corrective step. So I think we should not be that critical of the White Industries decision, because the court was stepping back from where it had ventured. The court had tried to be helpful in thinking that they were filling in gaps, but they forgot that the path to hell is paved with good intentions. So whatever the intentions may have been, they ended up creating more trouble.
Thank you so much, sir. I would now like to request our Vice President, sir, Dr. G.V. Rao, to deliver a formal vote of thanks.
Mr. Michael, Guiffre, and Mr. Laird, thank you very much for coming to the Indian Society of International Law and delivering your lecture on this very important subject, which is essentially to do with the larger umbrella of international commercial arbitration, of which we are all concerned, and some some of us have dealt with some of those issues. The niche area of investment arbitral decisions is not so prevalent except for a few cases in India. But by and by, India being a great investment destination in the recent few years, we are likely to see some disputes arise, and we would like to ensure that we have a fair judicial mechanism, especially the arbitration mechanism to deal with it. We have a world-class arbitration center to dealing with international arbitrations in Hyderabad, and one in the state of Gujarat, Guiffre, and one in Mumbai. So we are getting there, and we are dealing with arbitrations. Traditionally, we used to go to Singapore or Hong Kong or the London Court of Arbitrations, but experts like you visiting us, talking about us, would enhance our abilities to deal with arbitration, and our professionals and students would get into that culture of ensuring that we are well aware of these issues and the nuances of it, of which you have great experience. Thank you for the gift of the book that you have written, which will adorn our library. You've come all the way from Washington, D.C., and I hope you enjoyed your stay. I hope you enjoyed being with us. Mr. B.H. Parekh, who's our president, is a great host to all of this kind of activities. He supports us, and all of our international experts, Madam Lakshmi Jambolkar, Mr. Jambolkar, Mr. Crowell, all of these people have gathered here who don't normally come for all the events that are held at the ISI. So you are coming here as evoked great interest, and we are grateful for you. Thank you very much. A lot of students who have come from KLEF College of Law and KL University Andhra Pradesh. I'm sure you all found this thought-provoking, and it will help you to study more, understand more, and learn more. I'm glad you could all be here and attend a lecture of this world-class, literally, from counsel and attorneys from overseas. Ian, I think Ian, he also is a teacher in Georgetown University, a professor there. So, you have a host wealth of information which you must have, some of which you must have been able to catch. So I guess you feel free to connect with us online. I also see large number of people who have connected virtually, as you can see, and I'm sure they also have benefited. All of our events, we put them online, and everybody all over the world. We have a membership all over the world, the Indian Society of International Law over the years as a membership, and now everybody who's unable to come physically logs in and hears us. So you were heard by a lot of our things. Thanks to them as well. Thank you very much.
Thank you so much, sir. I would like to invite the students who want to take a photo. We can all gather here for a group photo. You can come on the stage.
Just a minute. Okay.
Thank you. All those the others who've not got a chance to get a picture, come quickly, please. Yes, come. They're eager to get a picture, right? Be fast. Come on, quickly. Yeah.
Excuse me, sir. One more.
Thank you.
इससे पहले वाली ग्रुप फोटो मिल जाएगी जी, इससे पहले वाली ग्रुप फोटो मिल जाएगी ना, फोन कर दूँगा, मैसेज कर दूँगा।